Welcome to the latest episode of International Law Chats, a podcast from the American branch of the International Law Association. The podcast airs on the first Monday of every month, and we hope you can join us each month for a new episode. I'm Milena Sterio, a professor of international law at Cleveland State University College of Law and managing director at the Public International Law and Policy Group.
And I am Chiara Giorgetti. I'm a professor of international law at Richmond Law School, a non-resident faculty at Vienna Diplomatic Academy.
Today, we're very pleased to be chatting with Judge Kimberly Prost from the International Criminal Court. Prior to her election as judge at the ICC, Judge Prost served as chef de cabinet for the president of the ICC for a 2-year term, and before joining the court, she was appointed in 2010 as the first Ombudsperson for the Security Council of Qaida Sanctions Committee, and in 2006, she also served as an ad litem judge at the Yugoslavia Tribunal. Earlier in her career, Judge Prost worked for the Canadian Department of Justice for 18 years, appearing before all levels of the Canadian courts, including the Supreme Court. She participated in negotiating over 40 extradition and mutual legal assistance treaties and was a member of the Canadian delegation for negotiating the Rome Statute of the International Criminal Court and related documents, as well as the UN Convention Against Transnational Organized Crime and Corruption. Judge Prost also held managerial positions with the Commonwealth Secretariat and the UN Office on Drugs and Crime. She graduated as a gold medalist from the University of Manitoba Law School. It is a pleasure to have you on our podcast. Welcome, Judge Prost.
Thank you very much. It's a real pleasure to be here.
I would like to begin by asking a little bit about the background of the ICC. You were actually present as a member of the Canadian delegation when the Rome Treaty was negotiated and adopted. When you think about the negotiations and where the court is today, do you think that some of the most difficult negotiation issues still affect the court today, or do you think that the court has been able to overcome some of those preliminary quote-unquote obstacles throughout its 2-decade-plus existence?
Well, it's such an interesting question. You really provoked a lot of thought with this topic, which I think could be the basis for an article or a book. And interestingly, when I look back at the negotiations, one of the things that strikes me is a lot of time and energy was spent on discussions of some issues that have not been at all dominant or particularly relevant in the practice of the ICC. I think from some of the ones I participated in, for example, objections to evidence on the basis of national security. Those negotiations were tortured, or competing requests for surrender. The Article 90 is just very complicated. They've not been particular issues that we've had to address. And then other issues, completely surprising issues, like the consultation provision in Article 97, which allows states to talk to the court on cooperation problems, has become the subject of debate in the Assembly and jurisprudence. Evidently, it could have used some more discussions at the negotiations. So those are the surprises of negotiation and practice. But as to your direct point on difficult issues at the negotiations, which have been perhaps resolved or remain today, I think there's several in both categories. I'm just going to touch on a few. One, which has taken time, but I really believe has achieved resolution through practice, is implementation of the hybrid legal system, and in particular, in terms of the details of the procedures to be used in the courtroom during the trial. So in drafting the Rome Statute, there was a commitment that we worked towards it being a hybrid legal system. So it's a blend of legal traditions and not tied to any particular one. But that was a really hard part of the negotiations, particularly in terms of procedures, because the systems vary so much, and how to manage evidence. And we were only able, with the time limits, to agree basically one general article and one rule. And so it was left to the judges, which isn't always the best choice, perhaps, to develop the procedures. And at the beginning, there was a lot of challenges. There was inconsistency. It would depend on which judge was presiding as to the nature of the procedures being followed in the courtroom. And that led to uncertainties and delay. But recently, we've had tremendous progress, I would say, in the last 5 or 6 years. with the development of a chamber's practice manual and conduct of proceedings, a model conduct of proceedings and guidelines on judgments. And I think we'll improve further because we've gotten in the habit now of agreeing these procedures. So I think we have a very functioning hybrid legal system, and that was something that we couldn't achieve through the negotiations completely, but we have done so through practice. In contrast, another issue which was highly contentious at the negotiations and remains so challenging for the court is state cooperation, the whole section of Part 9 dealing with cooperation. The court, as everyone knows, has no powers itself in terms of enforcement. It has no overreaching powers to issue subpoenas that are binding in states or to arrest individuals or gather evidence through compulsory measures. We depend entirely on the cooperation of states to do that. And that was a constant tension in the negotiations on how much vertical power the court would have versus those who wanted it more a horizontal entity in that relationship. In the end, it was a compromise, and states certainly retained their sovereignty, but there was a strong and absolute obligation to cooperate in arrest and surrender, evidence gathering, and especially in the case of arrest, there were no grounds of refusal. We eliminated all of them. And yet, despite this clearly agreed principle, we still see failure to comply, and perhaps most disappointingly, lack of action by the Assembly of States Parties and the Security Council were relevant in reaction to those failures to comply. So it's probably one of the most problematic issues. It was one of the difficult ones in the negotiations, and it still remains today. And the last one, which I will highlight, there's several others, but the last one was an issue which practice has clearly shown, contrary to the other two, it should have been discussed more and addressed with much greater clarity. And that was the issue of immunities and the relationship in particular between Article 27, which makes it crystal clear that official capacity is irrelevant to your role as a head of state or head of government, shall not exempt you from responsibility under the statute. And Article 98, which is clearly and was intended as a procedural article, which precludes the court from proceeding with cooperation requests, which would place a state in conflict with an existing international obligation. But it has been the subject of various interpretations, which have placed it in almost conflict with 27, which was never the intention in terms of the drafting. So, I mean, we can discuss that whole issue for the entire podcast, but we won't. But I just would identify that very much as one of the issues that still remain because perhaps there wasn't enough focus on it at the negotiation.
Thank you very much, Judge. This is such an interesting kind of overview of what happened and how it has resulted also in the operation of the ICC. Now, some of our listeners will surely also be interested, as I am, in finding a bit more about your own professional background. How did your professional path ultimately lead you to The Hague? How maybe you compare also a job as a diplomat? We heard your negotiation of the statute, then government officials to that now of the ICC judge, and maybe which one is more challenging?
Well, as I think is clear from my CV, I've not had a path that's quite usual to the court. I think some of my colleagues have had a much more, perhaps a judicial path or a more obvious route. Perhaps I think sometimes I fear my CV illustrates my inability to hold down a job. But while I practiced, and I'm very grateful for that opportunity, I practiced both domestically and internationally. And I loved all of the work that I've done. I'm really, really grateful for that and lucky to have had that. It was my work domestically, interestingly enough, which I think has given me the foundations that led to The Hague. It was my first 5 years, day in and day out in a courtroom in my hometown of Winnipeg as a prosecutor, skills that I still rely on to this day, things you learn through practice. 2 years I spent at the war crimes, the war crimes section of the Federal Justice Department, Crimes Against Humanity, War Crimes Section, which was just had been established. I was there at the very beginning, and it was at such an early time for international criminal law. That was a really, really important experience. And then almost 10 years working in international cooperation, extradition, mutual legal assistance. That gave me such a depth of knowledge of the different legal traditions in the world and the opportunity to negotiate treaties, which included the Rome Statute and rules. So I think it was that domestic experience, plus the fact that mid-career, I suddenly did this transition to working in a multicultural international context. I left Canada and worked at the Commonwealth and the UN in Vienna. And I think it was that combination that led the Canadian government to approach me first about being a judge of the ICTY. And then that cumulative experience led me here to the ICC. And as to the different roles, I've never served, of course, officially as a diplomat, but you're right, I've done many, many negotiations. So I like to think I lived a bit of that life and experience. I loved that role as well as being a prosecutor and an official for the government. There's so many different issues and cases, and especially in international cooperation, the variety and the excitement, arguing in court or assisting governments and domestic officials to navigate internationally. Those were all great jobs, but judge is the most different, the most distinct. You have to have, skills that are applicable in those other roles, but you also have to have the ability to decide on issues, to review facts and law, assess credibility. That's an incredibly difficult function. And the skills that are probably most important across all three, they're important for all three roles: advocacy and diplomacy. To navigate negotiations, you need that. To serve effectively in the government, you need that. And yes, even as a judge, working as part of a judiciary, you have to persuade your colleague and you have to maintain collegiality. So these are critical skills. But in terms of the most challenging role, they've all been fascinating. I've liked every job, but have particularly has to be being a judge, especially here at the International Criminal Court, where you have to have the ability to listen, to analyze, make decisions on a reasoned basis, and just the idea that you're trying to deliver fair adjudication, justice for victims, and judge individual criminal responsibility. It's the most challenging and I suppose in turn most rewarding role that I've had.
Thank you, Judge Prost. Now, switching gears a little bit, I would like to ask you a more substantive question about a particular case at the ICC. So you have been a member of various trial and appeals chambers in several cases over the past several years, but I'm particularly interested in the Al Hassan case and charges of gender persecution. And it seems to me that there might still be a divergence of judicial views about the crime of gender persecution. Do you think that this is the case? And if so, why? Is there anything different or unique about cases where at least part of the charges include gender persecution, which is a fairly new crime, and we don't have a ton of judicial precedent on gender persecution?
Well, I'm very glad you've raised this question because it is an issue very close to my heart. I guess I'd start by highlighting that if you look at the history of international criminal law, we have very unfortunately always had to make special determined efforts to change views and attitudes about gender crimes and gender violence. And it was the brave work of prosecutors and judges in the ICTR and ICTY, particularly in the special courts, which led to the proper recognition of gender crimes. But it took a lot of effort. I think of the FSA rape case in the ICTR, rape as an act of genocide finally recognized when intent is present. The jurisprudence of the ICTY on rape and sexual slavery as crimes against humanity. And then the ICC statute finally incorporating those crimes along with forced pregnancy and now recognizing through jurisprudence forced marriage. So it has been a journey to get that proper categorization and recognition. And when it comes to gender persecution, unfortunately, it has to be for some reason, a part of the same evolution. So yes, I agree with you fully. The Alison case clearly illustrates starkly different views on the interpretation of gender persecution. I've spoken very clearly as to my view in that case, and I remain firm in those convictions as a judge. And I have difficulty understanding how, at this point in time, we still have that kind of approach, a different kind of approach in view to gender persecution. I'll be very frank about that. And no, I don't think it's because there's anything different or unique about gender persecution. To the contrary, just as historically rape was not seen for exactly what it is, a crime of violence, gender is not being seen as the same as other forms of persecution grounds, and it should be. That to me is the problem. It's still getting some kind of specialized treatment. The one point I'm grateful on, though I do feel we're making progress, I would emphasize that while Judge Mundua acquitted on this charge in the Alison case, he did so on the basis of positive defenses. And the view that he and I shared as the majority as to the proper interpretation and application of gender persecution in the case, that it was factually and legally established, distinct from Mr. Alison's responsibility, it does form a majority view in the law of the ICC. And that has been used as the foundation going forward, most notably in the Afghanistan warrants. So we are making progress, but I really regret that we have had to go through this evolutionary process again. But I hope that the next step will be a major one forward.
Thank you very much, Judge. Let me maybe step back and look at things maybe more generally now. The ICC is a court which depends on state cooperation in its investigative and prosecutorial stage, including, as we discussed, in one of the most controversial topics, which is the enforcement of arrest warrants. At the same time, the ICC, through its positive complementarity mission, also has the ability to engage in capacity building with particular states. Can I ask you, how would you assess the court's relative success in its engagement with various states, and is there a room for improvement from both ends?
Yeah, it's a very interesting question as well. The short answer to it is absolutely. There's definitely room for much improvement. And as I've mentioned before, international cooperation remains one of, if not the most biggest challenge for this court. And there are obvious issues which surround things like the arrest warrants, where with 32 or more and counting, and not even involving those which we may not know about, which have not been executed. And there's a multitude of reasons for that. They can't be found, the situation is too dangerous, there's lack of prioritization, and of course, issues in some contexts relating to immunity. But the court needs to do more on its side in terms of state engagement on this issue, to present more complete information, to press states on prioritization. And at the same time, the states have to make stronger efforts, not only to cooperate individually, but to work together regionally and as a body to create conditions for better cooperation overall. So I think the engagement to some degree hasn't been sufficiently robust. And maybe in some ways, the engagement between the court and states has been individualized and focused a lot on particular scenarios or situations, as it must be. But at the same time, there hasn't been perhaps as good a strategy on both sides to the cooperation. But at the same time, though, turning more concretely to the state engagement issue, what we can't lose sight of is the fact that quietly, over the course of the years, there have been a multitude of successes in individual cases, particularly in gathering evidence and witness testimony in very difficult circumstances. So state engagement, though it remains challenging, it is also quite effective and really important. And the cooperation regime has many successes because of the engagement the court has done and hopefully can continue to do and perhaps do better. And as to your element of capacity building, yes, of course, that is a component, but it's a very limited component of what the court itself can do. It's always been the state's parties, in my view, that should be taking up a much bigger role in capacity building. But there is a natural capacity building when the court engages with states. I take the Democratic Republic of Congo. I've talked to officials from there. They know more about international cooperation than most states in the world do, because of a lot of the experience they've had and gained from interactions with the court. So you do see that benefit again from engagement, but that comes from individual interaction on cases. So what is clear overall is that on both sides, to advance, we need to improve on this essential aspect of our work of state engagement and cooperation.
Now, switching gears again a little bit, I did want to ask you about sanctions. As I'm sure all of our listeners know, over the past year and a half, several ICC judges, including you, and 3 prosecutors, including the chief prosecutor and 2 deputy prosecutor, have been the subject of U.S. sanctions. And as we all know, this is nothing new. The first Trump administration had also sanctioned the then prosecutor Fatou Bensouda, another high-level official. And on a more personal note, I was a part of a cohort of plaintiffs here in the United States who successfully sued the Trump administration the first time around. And I know that there's litigation ongoing right now as well here in the United States, and some preliminary successes there as well. I would like to ask you to tell us a little bit more about the impact that these sanctions may have had on the court, the impact on you personally, and perhaps most importantly, about the threat that such sanctions pose against judicial and prosecutorial independence.
Well, yeah, it's certainly an important topic these days for the ICC. It is of such importance because of the principles involved that I, myself, and other colleagues, judges, have spoken at some length, including media interviews, which is very unusual for sitting judges. But we've done so because it is so important to emphasize and explain the serious impact of these sanctions. They have an impact on many, many aspects of your daily life. And even though I had worked, ironically, in the sanction field for 5 years as the Ombudsperson for the Qaida Sanctions Committee, as you mentioned, and I had an idea because I interviewed many people subject to UN sanctions, until you experience it, you don't really understand the depth of the impact. So it begins with the fact that you have no credit cards whatsoever. It doesn't matter where they're issued, because of the influence of the United States in the SWIFT system and in the financial system generally. So they're canceled everywhere. And that impairs so many tasks you don't even think about, booking a taxi, a hotel, ordering things online, buying a Paris subway ticket. They was doing that all through credit cards, and you lose access to all of that. And then your banking services are highly limited. The bank will continue, unfortunately, in my case, banks are continuing to service me to give basic services, but every transaction becomes a gamble. You don't know whether a sending or a receiving bank will accept to deal with you, will reject your transaction, or it'll be even frozen or block your funds. And it's really disconcerting that everything becomes that complex. All services provided by American companies potentially are in jeopardy. And it's random as to which one's going to kick in. I was immediately had my Amazon account canceled, but it can affect Google, it can affect Apple, and it has far-reaching consequences. A much told story that I've recounted is the fact that I went home in the early days and I spoke to Alexa, asked about the weather, and she went little because she wasn't working anymore. So even she was silenced by the sanctions. So it's the randomness of it. And it's also the companies are pervasive in the technology field. So in many ways, those of us sanctioned here are living back in the 1980s. And one of the other impacts is the overcompliance. So even companies that are not American, that are not required to comply with these sanctions, do so. one of the most difficult effects of that right now for all of us, I believe it's all of us that are sanctioned, is our medical claims are no longer being paid by the French company that provides the court contractually with services on medical insurance. And they've just done it as a business decision despite their contractual obligations. You can imagine that's a very disconcerting and frustrating situation that we're still working on. But most importantly, I would highlight, I think for many of my colleagues, it's the impact on family that this can have, because it's one thing if it's yourself, but it can affect the visas of your children. If you have a spouse, for example, who's American, or a child, it's very complicated. You require licenses. And last, I guess, in terms of particular effects, there's situations where I wasn't able to make presentations, do lectures that I'd hoped to do because of the chilling effect and the concern of organizations about having individuals who are sanctioned appear, and some organizations that don't even really want to associate with me now that I'm sanctioned. So those are all very difficult and psychologically as well. And they're serious. Therefore, I think if you look at all of that, it has a serious impact on life. And we've wanted to shed light on that, but not from the perspective of woe is us, because compared to what we see in our cases, these are painful and annoyances. But the point is, this is happening to us because we are doing our jobs independently and objectively as judges, assessing evidence and deciding cases on facts and law. And be assured, in terms of the impact of these sanctions, we are completely undeterred in this respect. We will continue to do our jobs objectively and independently, and we will not be intimidated. But there should be no doubt about this, and it's the same for the prosecutors. What this is a direct attack on the independence of the judiciary, on the independence of prosecutors in the context of atrocity crime. These measures are applied to get us to do our job in a way that is satisfactory to the United States administration and to decide our cases in accordance with their views. That is impossible. And that is such an appalling attack on judicial independence. So, and that is why we're appealing to governments, to NGOs, to regional groups, associations, to the public, to stand up with us against this and defend the ICC in its efforts to bring justice to victims as part of safeguarding the rule of law. So it's a serious situation for us individually, but even more so for those important principles.
Thank you very much. I think a lot of listeners will not know what the consequences are of sanctions. So thank you for sharing your story. And I'm glad that you are undeterred, because I think there are very important principles that you have to maintain. So thank you. Looking forward now, more generally maybe, what do you see as the most important thing to ensure that the continued strength in the credibility and legitimacy of the ICC?
Well, it's, there's a number of important things. And first of all, we have to look at the situation, the current situation, in context. The International Criminal Justice Project is a relatively new project of international law. It was always going to be challenging and difficult. You're talking about individual criminal responsibility, and it's a topic that makes people very nervous in certain contexts. And it's clear that the work of the court has become more and more relevant. And I suppose in some ways it's natural that it's going to develop these kinds of complicated scenarios as a result. And it's the same, the general context, the sense that international law is under attack on so many levels. That's true, and these threats are all real, but we have to put it in context. It's a hard area, international law, and advancing these principles. And we have to believe, I believe very firmly, we have up periods, as we did when the Rome Statute was adopted, for example, and then we have periods of great challenges, which is what we're facing now. So I'm very much optimistic in that respect. I think there's some things that are very important, though, that we should be doing. First of all, states parties really have to, for the ICC itself, bringing it to that, states parties really have to support this court in all aspects. politically, obviously. They have to engage to safeguard the court, give statements publicly supporting this court. In the beginning of these most recent round of attacks, not only the sanctions, but the fact that some of my colleagues are subject of warrants, arrest warrants by the Russian Federation, and have now been convicted in absentia for offenses and sentenced. In the context of these kinds of attacks, and when the sanctions hit, perhaps the initial reaction, I think, from states was not strong enough, was not quick enough. But we have seen encouraging signs. The last Assembly of States parties, we really saw a coming together of states and a recognition, I believe, that of the need for this support, and also a good consensus statement to that effect. They also need to continue to finance the court in a reasonable way that it can carry out its mission. And they need, most importantly, to fulfill their cooperation obligations. This is not the judge's court. It's not the prosecutor's court. It's the state's court. And they have to recognize that, and they have to pay attention, much more attention to that. So I think that's very important. At the same time, I am not one who shies away from acknowledging that the court has got to continue to improve its performances, its efficiencies. It has to address problems. It has to be open to criticism and respond to constructive criticism, employ new ideas. What I spoke about earlier, I think, has been a very important advancement. We took very seriously. We had the independent experts report identifying a number of issues administratively and in judicial practice, and we've taken that really seriously in trying to advance and improve. And I think the court, if it expects support, not only from states, but from the public generally, from NGOs, it too has a role, an important role to play in ensuring its own credibility by improving all the time in how we do our cases and how we practice. And so I think that's really important component of this as well. And we are making progress, I think. And then for me, one of the things that's the reason that I do like speaking about the court, I speak a lot to students, to young people, is we need better understanding of the International Criminal Court. And it is not, importantly, the court is not a super court. It's not here to interfere in national jurisdictions, in national cases. It's part of a system. The whole idea of the Rome Statute is to cajole, encourage as states to take up their responsibility to investigate, prosecute these crimes. And it's only where there's no state willing and able to deal with particular allegations that the court intervenes. And that needs to be understood. That's the role of the ICC, and it's about a system for justice for victims. So the more we can spread that message, make the court more understood, the better it will be in terms of generating support from NGOs and regional groups and of course, just from the general public. And last, but certainly not least, the court was created by treaty. So there's 125 states parties, and that's a good number. But this court will only achieve full credibility, will conquer a lot of its problems if it achieves universal adherence. I know that's a goal that's not going to be achieved, probably not in my lifetime, but that can't in any way preclude us from striving towards it. And that's what we must do. The goal must be for universality. So all the efforts we can put towards enticing more membership in the Rome Statute, I think, are very important. So those would be what I would identify going forward as the things that I think are most important for the court and for advancing the Rome Statute system for justice.
Thank you so much. I simply wanted to give you a chance to address anything else or make any additional points, perhaps things that we did not have the opportunity to cover yet in this podcast.
Yeah, well, thanks. And I think it was a great conversation. I really enjoyed the questions, and I think I hope it's given a real impression to the listeners about what the ICC is about and about some of our current issues and struggles. One of the things, though, I just wanted to leave the thought was, because I participated in the Rome Statute negotiations, one of the amazing things I remember And no one who was there that I've ever chatted with about this has ever contradicted it. In that period of time back in the 1990s when we were negotiating, there were very different views in the negotiations of how the International Criminal Court should look, what the powers should be. There were some who wanted it much stronger, some who wanted it more deferent. There were issues about the role of the Security Council. There were all sorts of differing views, but there was one principle, one underlying spirit, if I could put it that way, or commitment of all the delegations. And I believe this is true across the board. And that was that there was an important need to establish this court and system to bring justice and accountability for atrocity crimes and an end to impunity. I really believe the delegations there were all negotiating with that belief in mind, that it was a shared value then. And I think it's because it's fundamentally something that's driven by the imperative of victims. It's driven because it touches on shared values amongst people. And I know that's hard to see in these difficult times. So what I hope for is that bit by bit, with continued efforts, we can bring that spirit back. That's really what I would like everyone to understand. The ICC is here as part of this system designed to bring justice for victims. And that's a value and principle of universal meaning that merits people coming together from around the world to support the court, the system, and to be committed to it. So I just wanted to emphasize that because I was reminded today thinking back to those negotiations. So that's what I wanted to add.
Thank you. Thank you very much, Judge Prost, for taking the time to join us today. And thank you for sharing your insights on all these important issues. I have, in fact, really enjoyed our conversation, and we all have. And if our listeners have too, you can join us on the first Monday of every month for more international law chats. And as always, also thank you to our podcast producer, Laurie Farid, as well as Freya Doty Wagner. Thank you very much, and see you next time.